The principle of law in criminal litigation is that of personal liability. This simply means that where I am to be arrested for a crime, it is either I committed the crime or I am associated with the committance of that crime and not another person. That is, I cannot be arrested in place of another person where that person committed that crime. Few days back, the Supreme Court gave judgment with regards to a case. This was precisely in January of this year, and now this case highlights the principle we are talking about in this video. Now in that case, the pastor of a church was arrested in place of his son. His son has engaged in a business transaction, and when the police came over to arrest the son, the pastor was instead arrested because the son could not be reached. Now the pastor was taken to jail and was kept there. Now this was a clear derogation of his right to human dignity as enshrined in the Constitution, and he filed an action at the Delta State High Court in Warri. Now at that court, the court said the pastor has no merit in the case and therefore he dismissed the case, and the pastor decided to appeal to the Court of Appeal. Now at the Court of Appeal, the justices of the Court of Appeal resonated with the principle of Section 7 of the Administration of Criminal Justice Act, which states that a person cannot be arrested in place of the crime of another person. That is, Mr. A cannot be arrested for the offense of Mr. B, regardless of whether Mr. A is the brother or the associate or friend or parent or anything associated with Mr. B. Where Mr. B commits an offense, Mr. B is to be arrested. Now this is the principle of the law. The case went further to the Supreme Court, and the Supreme Court still stand by the judgment of the Court of Appeal. Nobody can be arrested in place of another person. Where a person has committed an offense or is associated with the committance of that offense, that person ought to be arrested. The principle is that of personal liability and nothing else.